This is the second video of CRPC, and without wasting time, let's start with the MCQ. Our first question: then what shall be the term of imprisonment? We have got four options here. Option A is 3 months, option B is 6 months, option C is 1 year, and option D is 3 years. So the correct option is option B, that is 6 months. Let's move on to second question. Inherent powers under section 482 of CRPC can be exercised by, we have got four options here. Option A is any criminal court, option B is the Supreme Court only, option C is the Court of Session and the High Court, and option D is High Court. So the power under section 482, that is inherent power, can be exercised by the High Court only, so the option D is correct. Now let's move on to third question. A is accused of an act which may amount to theft or receiving a stolen property of criminal breach of trust or cheating. He is only charged with theft, but it appears that he has committed the offense of criminal breach of trust. He may be charged with, we've got four option here. Option A is acquitted, option B convicted of theft, and option C convicted of criminal breach of trust, and option C discharged. So the correct option is option C, that is convicted of criminal breach of trust. Let's move on to fourth question. Fourth question is, a person arrested by police officer may be kept in custody for how many times, or how many days, or how many hours? It can be anything. So a person who has been arrested by a police officer shall be kept in custody without obtaining the order of magistrate for a period not exceeding, we've got four option here. Option A is 2 days, option B is 3 days, option C is 24 hours, and option D is 1 week. So the correct option is option C, that is 24 hours. Let's move on to fifth question. Now, how much amount of monthly maintenance may be awarded in favor of wife under section 125 of CRPC? So what can be the amount which can be given to wife as maintenance under section 125 of CRPC? So we have got four options here. Option A is 300 rupees, option B is 400 rupees, option C is 500 rupees, and option D is at the discretion of the court. So there is no fixed fine, there is no fixed maintenance. I'm sorry, I'm repeating fine. There is no fixed maintenance, so it is at the discretion of the court. So the correct option is option D, that is at the discretion of the court. Let's move on to sixth question. In a first information, an offense is cognizable and other is non-cognizable. The whole case shall be deemed or be treated as. So the question is, if one offense is cognizable and the other one is non-cognizable, then the case shall be deemed or case shall be treated as what kind of offense? So we have got four options here. Option A is cognizable, option B is non-cognizable, option C it is to be seen whether it is a warrant case, and option D is it is to be seen whether it is a summon case. So these two options is out of box, that is C and D is out of box, and we have got two options. We can eliminate one of them. So the correct option is A, that is cognizable. When there are two offenses, one is cognizable whereas the second is non-cognizable, so it has to be treated as cognizable offense. Let's move on to seventh question. Is what is true about court of session? We've got four options here. It can take cognizance without committal. Option B, it cannot take cognizance without committal. Option C, it can take cognizance on the recommendations of district magistrate. Option D, it can take cognizance if the challan is put by the superintendent of police. So the correct option is option B, that is it cannot take cognizance without committal, right? Committal is done by the lower court of judicial magistrate under when the case is exclusively triable by court of session under section 209 of CRPC. So let's move on to eighth question. Eighth question is, no person shall be appointed as public prosecutor for the district unless his name appears in the panel of names prepared by. That means no person shall be appointed as PP, public prosecutor, unless his name appears in a panel which is prepared by, and that panel is prepared by which person? We have got four options here. Option A, session judge, option B, high court, option C, district magistrate, and option D, superintendent of police. So the correct option is option C, that is district magistrate. A list of panel is prepared by district magistrate. Let's move on to ninth question. How much punishment may be awarded to an accused who is found guilty under a summary trial? If any person is found guilty under summary trial, then what can be the punishment which can be awarded to him? We have got four options here. Option A is not exceeding 2 years. Option B is not exceeding 1 year. Option C is not exceeding 6 months, and option D is not exceeding 3 months. So the correct option is option D, that is not exceeding 3 months. Let's move on to 10th question. Is whether an accused may be a competent witness in his own defense. Can it be? Can the accused be a competent witness in his own defense? Let's see the options. We have got four options here. Option A is if it applies in writing on his own request. Option B, no. Option C, with the leave of the court, and option D, with the leave of the High Court. Now we can eliminate the last two options here. No leave is required for an accused person to be a competent witness in his own writing. So I have spoken about the writing. So the correct option is option A, that is if he applies in writing on his own request, right, he can be a competent witness. Let's move on to 11th question. Whether a magistrate is on opinion after hearing the evidence for prosecution and the accused that the accused is guilty and that he ought to receive a severe punishment that such magistrate is empowered to inflict, the magistrate may forward the case to. I think if you haven't watched the first video of CRPC, you go and watch that video. I've explained this question there. We have got four options here. Option A, session judge. Option B, chief judicial magistrate. Option C, district magistrate. And option D, concerned police station. These two options cannot be at all. We can eliminate the last two options. Why will a judicial magistrate send case to executive magistrate? Not at all. And this is also executive. So the correct option is option B, that is chief judicial magistrate. If a magistrate cannot pass the sentence sufficiently severe, he shall send the case to chief judicial magistrate or chief metropolitan magistrate. So these were the 11 questions for the day. Thank you so much for watching. If you haven't subscribed to my channel, please do subscribe. Hit the bell icon so that you get the regular notifications the moment I upload the video. Thank you so much.